Well, good afternoon, everybody, and welcome back to the Procurement series, which has been run over the last 4 or 5 months, and we are unhappily or happily, depending on how you view it, at the end of the current series, part 9. Today, I will be looking at the Commonwealth Contracting Suite and Commonwealth procurement policies, the connected procurement policies that apply and that we need to consider and put into our tenders and into our proposals and so on that we send out. So I'll be covering off on those and a couple of other things along the way. Before starting, I'd just like to acknowledge country. HWL Ebsworth would like to acknowledge the traditional custodians of the land on which we are today, and we would also like to pay our respects to elders past and present. Okay, well, as usual, when starting these things, it's just good to look backwards and forwards, which I usually do, but today is just looking backwards. So, as I said, we are at part 9 of our series, procurement series for this year. We will be doing more of these next year, and we've had some great interest. We've had an average of about 200 people tuning in every round about fortnight or so. And next year, we might space them out so they're 3 weekly. There'll be some new sessions and an update of some of the sessions we've run this year. So we've taken you through the full procurement cycle, planning, observance of probity, some current issues, looking at some of the ANAO reports, legal issues, the art of tender assessment, managing a procurement, managing the contract, some prickly issues in procurement and case studies on things like more stories, and lastly, the Commonwealth Contracting Suite and the Commonwealth Procurement Policies, which I'm presenting on today. As I've said before, if you've missed any and you'd like to get a recording to share with your colleagues, then and to obviously watch yourselves, then please reach out to Katerina. Her email address is there. And if you did attend and you'd like to get a copy of the recording or a link to the recording to share with colleagues that you think might be interested, you're most welcome as well. So please feel free to do that. So the Commonwealth Contracting Suite, let's start with the CPRs. What a great place to start. We should start always by looking at the source and the root of these things. So the CPRs mention the Commonwealth Contracting Suite in a couple of places. Specifically, CPR 2.4C says that templates such as the Commonwealth Contracting Suite, which simplify and streamline processes, creating uniformity across Commonwealth contracts to reduce the burden on businesses when contracting with the Commonwealth. So templates are good for that. They create uniformity. They give confidence to both the contract administrators that are administering these contracts at the departments, at the government, within the Commonwealth, but also to the private sector businesses that can become familiar with these forms of contract. So it's good to have well understood and contracts, and those contracts with people with experience of administering those contracts. So that's the benefit of these things, and the CPRs puts that front and center at 2.4C. It then goes on to say at CPR 6.10 that non-corporate Commonwealth entities, NCEs, otherwise known as NCEs, must use the CCS suite for contracts under $200,000. And corporate Commonwealth entities are encouraged to apply the suite of templates. So that's the next point. So if you're an NCE, you've got to use them unless there's an exemption. There's always exemptions. That's the way these things go always. So we'll come to those. But if you're an NCE, basic starting position is any contract under 200,000, I've got to use it. And if you are a corporate Commonwealth entity, a CCE, then you don't, but you're encouraged to use it. There's then some references in the suite guidance documents themselves, which talk about recommended for use up to $1 million, but the mandatory use is under 200,000. Now, whilst we're talking about the CPRs, I should mention CPR 7.4 as well. And this is referred to in the Department of Finance's contract management guide, which is a good document which I have had cause to look at a number of times. The contract management guide published by the Department of Finance. And I think whilst we've done a session on contract management, and contract management is extremely important. So, you know, we've gone through all the issues around that and taken out some good learnings from the contract management guide. Obviously, when talking about contracts, nothing happens in a vacuum. And so when talking about contracts generally, we should always have regard to supporting documents and guides and other resources, such as the Australian Government Contract Management Guide, updated at July 2023. And that's available on the Department of Finance website. And CPR 7.4, obviously that's in the Commonwealth Procurement Rules as a rule, but it's also directly referenced in this contract management guide, and it says contracts should be in written form. So whilst as a matter of just law, contracts don't have to be in writing, they can be other than in writing. CPR 7.4 says that they really should be in writing. And that just makes sense anyway. As a matter of, as a general statement, contracts should be in writing because that deals with a whole lot of problems you might otherwise encounter, but the CPRs make that very clear, as does the contract management guide. And obviously the contract suite, Commonwealth Contracting Suite, is in writing. So that printed out, properly filled in all of its relevant sections and signed, then becomes your written contract. So I wanted to make reference to the CPR 7.4 as well, whilst we were just paused on the CPR slide as we are now. Okay. So Resource Management Guide 420, Resource RMG 420 is a management guide all about the CCS. Once again, it says mandatory use of the Commonwealth Contracting Suites for procurements under 200,000. The guide is relevant to all non-corporate Commonwealth entities, NCEs, and corporate Commonwealth entities are encouraged to apply this policy. So just like you're encouraged to use the suite, this suite guide says the suite is compulsory for under 200,000 because it doesn't apply to CCEs automatically. But just like the suite, CCEs are encouraged to apply the suite of contracts, and then obviously this guide. Okay. So what does it say about the RMG? What does it say about RMG 420? Sorry, what does it say about the Commonwealth Contracting Suite? Well, a few things. It says that the suite is designed to minimise the burden on businesses in contracting with Commonwealth Government and to streamline and simplify procurement processes for Commonwealth entities. So that is a repetition of the CPR, but I think it's relevant to do that. So when you're sort of looking at a separate guide, rather than cross-referring back or relying on people knowing what things say, then it's often good just to give it a place in the world, and that certainly gives it the place. That's what it's there to do, is to minimise burden on businesses. And if you speak to businesses, particularly smaller businesses, they will say that dealing with government generally, whether it's local, state or Commonwealth, but particularly state and Commonwealth, sometimes the procurement compliance and contract management compliance can be a bit burdensome. And so the more streamlined and more efficient that can become, then the better it is for everybody. As I say, both the department personnel and the APS people managing those contracts, but also the contractors themselves. There are some mandatory components to the guide and to the Commonwealth Contracting Suite. So the suite contains mandatory parts. The mandatory parts of the contract suite, because it's a whole sort of package, are the approach to market document itself, which incorporates the glossary, so the defined terms, the approach to market terms, otherwise known as tender conditions, and the response to the ATM or approach to market part, which is basically the returnable schedules or the bit that the respondent fills out. And also the Commonwealth contract itself, so that's the terms and conditions, being the glossary and the Commonwealth contract terms. So we put all that together. That's what's mandatory. We put those things in the approach to market terms, the response form, forms the Commonwealth contract itself. And then there's a range of non-mandatory documents as well to think about and to consider. There's a useful decision tree to determine if the Commonwealth contracting suite is right for a specific procurement, and that can be found at the Commonwealth contracting suite website, which is ccs.finance.gov.au, and there's a reference to it there. I think these slides are sent out to registered people. If they are, then you'll be able to click on that slide and you'll be able to go straight there. And that decision tree takes you through what are you doing, what sort of contract is it, how much is it for, what type of work is it for, etc., just to help you decide upon whether or not the CCS is right for you. Remembering the starting point probably is that, you should start from a position of, well, if it looks like it might work, then let's use it because it's mandatory. But if there is a reason not to, then let's look and see whether or not it falls into naturally an exemption. And we'll come to those exemptions in just a moment. So NCEs must use the CCS when they are purchasing goods or services under $200,000 where a formal contract is required, except under Part 2 of the Resource Management Guide. And Part 2 of the Resource Management Guide takes us through some of the exemptions, which I will look at in just a second. For procurements over $200,000 but under $1 million, use of the CCS is encouraged consistent with the RMG, because use of it is to be encouraged, but as it says, consistently with the RMG. So if there's a reason not to, then there's no need to, but it's encouraged. So what are the exceptions? Exceptions are set out in Part 2 of the RMG 420, as I've said, and they're listed here. The first one being where you don't need to have an approach to market or a contract at all. For example, procurements of under $10,000. So where we've got a procurement of under $10,000, we don't need to use the Commonwealth contracting suite because there is no requirement for an ATM or a contract in any event. The next one is where it's industry practice to use a supplier's terms and conditions, and any resulting risks from doing that are acceptable to the delegate and subsequently managed. So that comes with a couple of things. So firstly, how do we know it's industry practice, I suppose? And you might just form a view that some industries do have a general sort of practice of using their own terms and conditions, and there are some. Obviously, sort of the IT world and the telcos and that kind of thing, they tend to have their own standard forms, and there are some others. But we can't just leap to an assumption that just because a provider is telling us that it's industry practice to use their terms, then they're to be used. It's where the contract is just so unusual, or the type of work necessitates a particular type of contract, because the risk allocation that you find as presented in the CCS just wouldn't be accepted by the contracting counterparty. So that's sort of where you'll find it. Examples are IT and so on. You come across some industries where this kind of thing applies, but that's the first question. Is it industry practice or not? And how are we going to justify that? Because ultimately it needs to be something that a delegate is comfortable with. So we'll need to write something up, a briefing note or something like that, which puts this position. Delegate, we need to use a non-CCS contract, which would otherwise be mandatory, because in this instance, it's industry practice to use a supplier's T's and C's. But you can't just stop there. We then need to go on and say, oh, but by the way, using a supplier's terms and conditions comes with some risks. And we've done a risk assessment, and the risks that we've identified are these. And so we're putting you on notice of those risks that wouldn't apply if we use the CCS, but do where we don't. And those risks would be around title transfer, acceptance, things around acceptance, defects, liabilities, obligations on the contractor to do certain things and to, for example, indemnify you, intellectual property regimes and positions also. Those sorts of things would be the sorts of things that might pop up. You have to identify those where they'd be different, and then the delegate would have to consider those and find them to be acceptable. So that's a process. and comes with some sort of paperwork, some delegation, some sign-off, which would all need to be thought about and considered. So that's the second of the exemptions. The third one is where you're using a whole of Australian government arrangement or standing offer that prescribes other terms. Then you use those other terms. The good thing about that is those terms will have been considered at the Commonwealth government level and promulgated by the Commonwealth. So that's fine. The next one is a direct reference to ICT goods and services, but what it does is says don't use the CCS for these, use the digital sourcing contract templates instead. And there's a reference and a link to those on the CCS guidance website, which was referred to previously. And they're just contracts for the sourcing of digital things, be it ICT goods or services, consulting services, hardware, combination of the two, maintenance services, whatever it might be. So there are some templates for that. Those templates may be accepted by your contracting counterparty, or because of the industry may not, and they might require or demand that their terms be used, and that might be the only way that you can get what it is that you need, in which case, as I said, you've got to identify the risks, make the delegate aware of them, and have them signed off. Next one is exemptions for construction work, specialist scientific equipment, or specialist military goods and services. So that's an exception to the mandatory use of the CCS. So we've got certain construction contracts that are used by the Commonwealth. It sort of varies around the place. So sometimes you might use an Australian standard, sometimes it's like AS 4000 or AS 4300 or 4902, for example. Sometimes you might use an NEC, a new engineering contract version 3 or 4. So that's a contract from the UK used for these sorts of things, a suite of standard form contracts. I know they're used by at least one Commonwealth government entity for one project I'm aware of. There's also Commonwealth government drafted construction contracts like HC1, for example, the defence contract, which is used. And so there's things like that. So you don't need to use the CCS for those sorts of things. Also, it's quite likely that if you're getting construction work done, you're spending more than $200,000 anyway, in which case use of these contracts is not mandatory. It's encouraged up to $1 million and unsuitable over that, according to the guide in the suite. So that's that. So the next one, specialist scientific equipment. Again, you don't need to use it if you're procuring or installing or customizing some specialist scientific equipment. And then there is, as I mentioned before, specialist military goods and services. And we know, I'm sure a lot of you know, that the Defence Force has its own bespoke contracts, the Australian Standard Defence Contracts as DEFCON suite, as well as its construction suite and other suites as well. So that is that. The next one, another exemption doesn't apply to procurement under paragraph 2.6 of the CPRs. That's the paragraph that basically says that the CPRs don't apply to procurements of a particularly sort of critical nature and particularly significant nature, particularly in relation to things like defence of the nation or health and welfare and things like that, in which case an accountable authority instruction is required in order to exempt parts or all of the CPRs. Often part 2 of the CPRs is struck out. And we saw its application for the Department of Health through COVID, and it's a routine exemption used by Defence. Now, just because you might be striking out part 2 of the CPRs, you still should apply the CPRs in full where you can, because you've got the ability to not follow a particular CPR because rule paragraph 2.6 says that you don't have to. If you can, you should still, because obviously it's best practice. It allows you to maximize probity compliance and so on. So observing all of the CPRs is important. However, if you are undertaking a procurement through para 2.6, then that is another place where you can take the off-ramp from the use of the Commonwealth contracting suite and not use it if you want to. The next one is where you've undertaken a formal risk assessment, and that formal risk assessment indicates that a bespoke contract is required in order to manage specific risks. So again, a couple of parts to that. You need to firstly undertake a formal risk assessment. And that formal risk assessment has to pose the question and answer it. Are there some special risks here that aren't dealt with under the CCS or can't be easily managed by the insertion of a couple of special conditions, for example? And if that is the case, then you may need to come up with an entirely bespoke contract. Presumably, again, that would have to be considered by and signed off by and approved by a relevant delegate, were that to be the case. The next one is the procurement is significantly impacted by prescribed terms. These are guarantees and warranties implied by law, which can't be excluded. And the reference there is to lease agreements. So there's just a missing L on the beginning of that ease. It should be lease, e.g. lease agreements. So that can be the case, and where it is, then you don't need to use the CCS for a lease. Or in this world or in this context, you can use a standard form lease agreement because of these, in quotes, prescribed terms, which is defined through the Commonwealth Government Contracting Understanding prescribed terms, and as I say, they're conditions, guarantees implied by law. So in those examples, you don't need to use the CCS. And then the next one is where both procurement and delivery, both procurement, so the procurement of the item, and the delivery of the item, both of them will take place outside of Australia. So if you're procuring from an international supplier, but the delivery occurs in Australia, you've got to use the CCS. But if both procurement and delivery take place outside Australia, you don't. The other thing I found interesting, by the way, was when I was looking at the Department of Finance's website in relation to the CCS and elsewhere, and it said that the Commonwealth Government and use of the CCS is not something to which the recently commenced unfair contract terms regime applies. The amended regime, I should say. So the regime came in around 2017 or thereabouts. Originally, unfair contract terms can't be in contracts or can't be enforced in contracts with small businesses. Basically, that law. Well, that law's gone through a lot of changes, and this presentation isn't about that, so I won't dwell on it too much, but it's good to know. The changes it went through are a significant expansion of the definition of small business, so it's grown from 20 to 100, and also a dropping of the financial threshold below which it applied. It used to apply only to contracts of $300,000 or less, unless it was for a term of over 12 months, in which case it was $1 million or less, but that's gone. So now it's a standard form contract with a small business defined by reference to employee number, changed from 20 to 100. And even if you get through that, so you're dealing with a company with 120 people, if their revenue's under 10 million, they're still considered small and the regime applies. Now, the Department of Finance on its website, on the CCS, in relation to the CCS, says that the CCS has been drafted, developed and considered in line with and to comply with that legislation and that requirement, but otherwise technically doesn't apply to the CCS when being used, presumably by NCEs. It would have to be by NCEs. It would apply to CCEs, I would say, almost definitely. But in any event, that's just interesting. I think I just find that interesting. So so that's the position, and I think it's a good policy position to have, because if the Commonwealth Government passes laws that says contracts with small businesses aren't to contain unfair terms, then you know, you've got to lead by example with legislation which comes from the government in that way. All right, it's enough about that. Let's move on now to looking at the suite itself. So we've got an approach to market, we've got some contract terms, we've got purchase order terms, we've got deed, ATM terms, deed, standing offer terms, and then glossary and interpretation. So just briefly, a couple of terms I've just plucked out of the ATM, just the approach to market, conditions of tender, just for interest. We've got ATM clause 1.4. So there's a sort of exclusion, an implicit exclusion of the process contract. So the process contract, for those of you that just need a quick reminder, is the law that applies to procurement and tendering, which says that there's a contract behind the way that you conduct the assessment and run the process. And if you conduct the process and run the tender in a way that's not consistent with the stated conditions that you've said you'll follow, criteria, closing dates, the way that you deal with late tenders, stuff like that, then there's a breach of the process contract, and a tenderer technically can sue you for breach of process contract, and that's the law behind process contracts. Now, since that law came to Australia in 1997, thanks to our friends Hughes Aircraft and Air Services Australia, there have been a few cases where the tendering and procurement's gone before the courts, and one of those was to sort of a few of those have canvassed whether or not you can exclude the process contract from even applying, just by saying there is no contract behind the undertaking of the process itself. Yes, there's a contract at the end of the process when we've gone through our assessment and we've got a contractor that we want to engage with, but prior to that, there is no contract. So there are clauses in a lot of approaches to market conditions of tendering at all levels and the private sector that seek to exclude the process contract altogether and or liability for it. And you can also find those in the tenderer's deeds of undertaking as well, sort of a strapping up or a belt and braces restating of the exclusion of process contract and exclusion of liability for it. So that's all very interesting. Clause 1.4, in very simple terms, seeks to exclude the process contract by saying there's no relationship of contract between respondent and the Commonwealth until such time as a contract is entered into. So in other words, saying there is no other contract around this at all, just that's the only one. So that's helpful. Now, I should say, just because we've got a process contract exclusion, let's assume that's effective. That's not actually been tested. The one time it was tested, for those lovers of procurement out there, which I'm hoping is all of you, the one time it was tested here in Australia was in the case of, I shouldn't say one time, it's been considered twice actually, but there was the case of Cubic Transportation Systems versus New South Wales government in a state government tender, and it wouldn't matter, the same rules would apply, state and Commonwealth. So it was considered there, and the judge found the exclusion of process contract clause would not be effective. And I'll leave it to you to read the case and see why. The reason, in short, was because there was a clause that said the process contract doesn't apply, but there are a whole lot of clauses that created a contract, and the judge just couldn't reconcile that inconsistency and said, you really can't create something and then by the stroke of a pen say it doesn't exist. It either exists or it doesn't. So that was interesting. And then the next one was Australian Jockey Club case involving, again, versus New South Wales, the Australian Jockey Club, which considered an exclusion of process contract clause and found it to be valid. So in that case, it did operate to exclude the operation or the existence of a process contract. So we've got two cases, both in New South Wales and both saying different things. So that's unhelpful, but that's the law. In any event, and this is probably the killer point really, the Government Procurement Judicial Review Act still definitely applies. And that came in 2018. Hasn't had a lot of action since, but I'm sure that each day will come where any breach or alleged breach of the Commonwealth procurement rules gives rise to a tenderer's ability to complain about the process and the breach or purported breach, freeze the process, and take compensatory / injunctive action, that is seeking compensation against the government for wasting its time and money on putting in for a tender, and also a potential injunction to either stop the government doing something, like entering into a contract, which they're about to do with a tenderer that is fruit of the poisonous tree because they should never have been selected, or to injunct them into doing something. So an active, an injunction that requires the doing of something rather than the restraining of the doing of something. So you can take either course, such as go about the tender procurement process again with a new committee, for example, you could ask for anyway. So that's in there. An exclusion of process contract clause won't exclude that. That cannot be excluded, actually. There are various things you can do with it, which we've talked about, such as public interest certificates. I mean, the best thing you can do is not breach the CPRs, of course, but if you wanted to have double protection because you can't stop somebody complaining for an alleged breach of a CPR, then you might put in a public interest certificate. Anyway, that's a discussion for another day, and we've kind of had it, and we'll be having it again next year when we talk about updates and procurement series and do it all again. But just the process contract exclusion, that's what led me down this rabbit hole, is good, and it's relevant, and then it's sort of but it springing from that are a couple of things that we just need to keep in the backs of our minds. Next one, the validity period for a CCS ATM, so a Commonwealth Contracting Suite, or a standard template approach to market. Validity period is 90 days. It's fine. When I first started in procurement, it was 30. It's now grown. Here is 90. In other tenders I look at, larger than the CCS ones, they are 180, and then also you've got to wonder in the world of the Procurement Judicial Review Act, actually, where a tender may have to be suspended whilst a complaint is investigated, whether 90 days is long enough. So food for thought. But anyway, the ATM provides for 90 days as a validity. I mean, again, that's a two-edged sword. You need to reserve yourself enough time to award the contract, but it's a bit unfair in today's market with volatility of prices and uncertainty to lock a contractor into a fixed price for any longer than that, really. In fact, some would say that 90 days is too long. Okay, next one is prices must be in Australian currency. That's 4.2D. Not particularly controversial usually. If you're dealing with an overseas contractor, though, they may not want to deal in Australian currency, and they may want for it to be paid in their source currency. And there are some interesting things around that, and Treasury / sort of finance guidance around who takes currency risk effectively, and forcing either contractors or tenderers into positions of hedging, or yourselves. Excuse me a minute. Yourselves are having to hedge. Okay. Next one is criteria. So there's some listed: extent to which response meets requirements. So I've just got my daughter texting me. Okay. And so they're of equal weight: extent to which response meets requirements, extent to which it demonstrates capability and capacity to provide the requirements sought, whole of life costs, indigenous participation, and then just general viability. Next one is conflicts of interest. So that's an ongoing obligation, so tenderers need to identify any conflicts they've got. Then the governing law of the contract is the ACT. Next one is specified personnel. Next one's indemnity. You get an indemnity, so that's just the use of specified personnel, and the fact that the tenderer needs to continue and commit to using the personnel that it specifies. The next one is the an indemnity. The indemnity is pretty fair, to be honest. It's only in the occurrence of negligence or a breach. Then termination or reduction for convenience, termination for cause, transition clauses, and then NAC Act, so that's the Anti-Corruption Commission Act requirements, is a new clause, 21.K, which you should be aware of. It's quite interesting. And then last one, notification of significant events, which has come about since we've had some issues with some contractors and some findings around breaches of confidentiality and other things. I'm obviously referring to some of the large consulting engagements and some of the fallout from that, which is where that particular clause has taken a bit of a life of its own, which is good. So notification of significant events. If I'm a contractor, I'm the subject of a, in quote, significant event, which is a finding by a tribunal, court, or other regulatory body about anything, then I'm to notify. There's to be a rectification plan, and so on. Okay. The Commonwealth Purchase Order really is very similar, if not entirely perfectly in sync with the Commonwealth contract terms. So I'm not going to go through those again. The clauses I just went through are similar to those. The Commonwealth Deed of Standing Offer approach to market terms, there are tender conditions approach to market terms similar to the standard ATM, very, very few differences, just a couple of references to the fact that it's a deed of standing offer, but otherwise the terms are the same as you'd expect, and the same with the deed of standing offer terms themselves. The commercial terms are also the same. There's two sample documents, quite handy on the CCS website actually. So not only do you get the terms and other things, but you also get some samples. And when going through those samples, look at key information and date. So are you having an industry briefing? You're having a site inspection? When is the question closing date and time? So if tenders are allowed to ask questions, do you need to put a date and time by which they must have those questions in order for them to be considered? And be very conscious of that. I was running a procurement recently, or was advising on one on behalf of the Commonwealth, and it was a covered procurement. GPJR applied, and a tenderer asked a question after the cut-off date. So cut-off date was 5 business days, 5 business days prior to the tender close date, and they asked a question within that period. And of course, that's not fair on tenderers that might have their tenders completed without the benefit of the answer to that question. So that's the point for the cut-off date, really. The procurement to the Commonwealth Contract Officer was minded to respond to it, and I said they just can't. And the reason they can't now is because that would breach effectively. If they just breach, that'll be a breach of the conditions of tender, which could give rise to a GPJR Act complaint. So we just got to be really on our toes about stuff like that. We also need to be on our toes about where we might receive a question outside of an authorized channel. So a question that comes in an RFI from a tenderer, not to the tender box, which is all through AusTender as prescribed, but through to somebody they happen to know, or to the personal email address of the person who actually is behind a mailbox that you might have set up. Now, whilst that might look and feel the same, it's different, and again is a sort of deviation from the way you say you run the process, which could give rise to a breach of process contract type claim. Or GPJR claim, indeed. So that's another one. Minimum content and format requirements always need to be thought about, as do conditions of participation. Again, think about what they should be, because if they're not observed, then that might lead to a tender being not selected or not eligible. Next one is security requirements. Do you need a tenderer to be at a particular security clearance level? Then we've got a couple of clauses: intellectual property and payment terms or additional contract terms that are put into the contracting suite. And then there's an invitation for respondents to not comply with the conditions, even though when you look at some FAQs and things, it says that you have to comply. There's a table inviting tenderers to state non-compliances. So a bit of inconsistency there, actually, but I think in fairness, you probably should put that in. I mean, it has to go in into this as it's templated and so on, but it's good to inform tenderers really that these conditions have been well thought out, they're considered fair, so let's not go changing them too much. There's a sample contract then, which goes on to talk about standards, performance measures. So if you've got KPIs and performance measures, think about those. It talks about security requirements again. There's a contract price. Is that fixed? Does it adjust? And then an additional contract term there as well, IP, payment terms, and the workplace gender equality. Then there's annexes, then being, and this is in the sample, conflicts of interest management plan, supplementary information. So FAQs, does the CCS meet the unfair contract terms legislation? I've covered that. Are the terms negotiable? It says no, and as I say, that is a bit inconsistent with inviting tenderers to put through in a table of departures. But anyway, we'll just leave that as it is, but just note that that is just there as, and it is a little inconsistent. Okay, then those FAQs, there's a number of them. These are just the ones that I found interesting or thought I'd speak to, but there's others and you can find them on the website. We'll now go to the procurement connected policies, or procurement policies more generally. Some of these are the procurement connected policies. Some, they aren't all procurement connected policies actually towards the bottom, but the first 4 or 5 are payment times, Shadow economy used to be called black economy, now called shadow economy, and there's a lot of references on websites, departmental websites, which still refer to black economy. It's been the name's changed, so those should be updated where they can be. IP Indigenous procurement, workplace gender equality procurement, Australian industry participation plans for government procurement, code for tendering and building works, and so on. Environmental sustainability and broader benefits to the Australian economy. So we'll just go through each of those now in turn pretty quickly. Payment times, procurement connected policy comes in from 1 October 2021, applies to contracts with a value of over $4 million and requires large businesses, those being reporting entities under the Payment Times Reporting Act 2020. And to be that, they need to have a revenue of over $100 million, by the way. So this will not apply to all that many contractors, but nonetheless, where it does, then these clauses need to be in the contract and also observed. Where those businesses are awarded government contracts over $4 million, they're required to pay subcontracts valued up to $1 million within 20 days. So it speeds up payment of smaller businesses. There are flow down requirements. So the subcontractors also need to put those into their contracts with their subcontractors where the subcontractor value is over 4 million and they're a reporting entity, and they flow down to the parties underneath them. All non-corporate entities must comply with this. So its application is to all NCEs. Other Commonwealth entities encouraged to apply. So that's a quick snapshot of the Payment Times Procurement Connected Policy. Some FAQs. Does the policy apply to overseas procurements? No. If partly local and partly overseas, then it applies to the extent of its to the extent it's local. Does the policy apply to real property procurements, including leases and licenses? No. Shadow economy, as I say, used to be called black economy, now shadow economy. It's all about tax compliance, effectively. Presumably a number of you would have come across it. I remember when it first came in, there was enormous confusion over this. Effectively, anything over $4 million, a contract over $4 million, businesses are to provide a statement from the tax office showing a satisfactory tax record for the past 4 years. All NCEs must comply. CCEs are encouraged to adopt the policy, however. Part 8 of the policy, it relates to new and foreign tenderers, because if you're a foreign tenderer, you are not paying tax in Australia necessarily, and if you're new, then you haven't got 4 years to show. If that's the case, the relevant tenderer is able to comply with this policy and the requirement by filling in a declaration that says even when Australian tax obligations come up, they'll comply with them. A declaration they are new or foreign. A declaration there are no tax-related convictions in the last 4 years, and a declaration saying they are complying with their tax obligations outside of Australia. And this obligation or this policy is for contracts over 4 million, but also panels where the total value of the panel collectively is over 4 million. So that's a point just to understand. Shadow economy FAQs, does it apply to existing contracts if they sort of go up, predate 2019? The answer is no. What if you don't get the satisfactory statement of tax record before tender closes? You must get it within 4 days of tender closing. If you don't, the tender can't be considered. So that's pretty serious. What you do if the tenderer says they've got issues getting it, refer them to the ATO. Phone numbers are given. What if we estimated the contract was below 4 million but came in at over 4? You don't need it. It's the estimate that matters. But just be conscious that people sometimes fudge the numbers a bit so that they don't need to get some of these compliance requirements up. And if you're in procurement, I'm sure you've come across that a number of times, like I have. Is it necessary for applicants to submit STRs when a panel originally established was prior to 1 July 2019 is refreshed? No. Can a procurement officer find out details from the ATO about a tenderer and tax compliance? No. Personal privacy reasons prevent that from happening altogether. IPP. What does it do? It's intended to stimulate Indigenous entrepreneurship and business development, providing Indigenous Australians with more opportunities to participate. It's got 3 components: target for purchasing from Indigenous enterprise, mandatory set aside to direct some Commonwealth contracts to Indigenous enterprise, minimum Indigenous participation requirements for certain Commonwealth contracts. Applies to all NCEs, subject to the CPRs. and other entities are encouraged to adopt the policy as best practice. Workplace gender equality, effective 1 August 2013, so been in place for a long time. Threshold is at or above relevant procurement thresholds. Tenders that have over 100 employees must be able to demonstrate compliance with the Workplace Gender Equality Act by supplying a letter of compliance. Doesn't apply to overseas suppliers if the law itself doesn't apply to them, only applies to suppliers with commercial presence in Australia with over 100 staff. So that's another policy. FAQs, I had 100 or more employees for 5 months of last year, but not for the remaining 7. Do I need a letter of compliance? No. How do I know the supplier should have included a letter with their tender? The approach to market should have a declaration in it requiring tenders to identify whether or not they are a relevant employer. So that's a question asked to an FAQ for respondents. Do I need to check the list of non-compliant organisations on the workplace website? No. The declaration sort of is designed to do that for you. Next one, if a supplier has not indicated if they're a relevant employer and not included a letter, can I exclude them? Get advice from internal legal probity or wherever you need to get advice from, but that's what's referenced in the FAQ. Do the principles apply to all deeds of standing offer arrangements? Yes. So there's the FAQs on procurement, on the WGA Act policy. Next one. Australian industry participation plans. So for major Commonwealth government procurements, over $20 million, effective from 1 January. Tender is required to prepare and implement an AIP plan. Key objective, Australian industry, especially small, medium enterprises, should have full, fair and reasonable opportunity to supply goods and services to eligible Commonwealth government projects. The AIP is about how an entity will familiarise itself with the capabilities of Australian industry. It doesn't mandate the use of Australian industry, and that's often misunderstood. Policy applies to NCEs and not to CCEs, but CCEs may choose to apply, is what the policy says. Okay, next. Procurement connected building codes, so they don't apply anymore. They've been repealed. So basically the bottom line is don't worry about those. So they've gone. Okay. Next one, environmental sustainability. So we're outside of the connected policies now. CPR 4.5 says that officials must consider environmental sustainability of proposed goods and services, gives some examples such as energy efficiency, environmental climate change impact. Then it goes on to say the reason for that is to recognise Australia's commitment to sustainable procurement and required to consider the Australian Government's Sustainable Procurement Guide. Now we've looked at that and the Sustainable Procurement Guide is available from the Department of Agriculture, Water and Environment's website. Okay, CPRs specify when assessing value for money that you need to consider environmental sustainability. There's a reference to the guide. The guide provides step-by-step guidance on how to consider sustainability in different stages, and it applies to NCEs and prescribed corporate Commonwealth entities, this obligation to consider sustainability by application of the Sustainability Procurement Guide produced by the Commonwealth. The sorts of things to think about: energy consumption, greenhouse gas emissions, reduction of waste, use of recycled products, reduction in hazardous substances, packaging, and end-of-life recycling. Sustainable procurement practices include devising strategies that reduce demand and extend the life of the product, planning what happens with a product at the end of the contract, how it'll be reused, recycled or disposed of to encourage potential suppliers to address this from the beginning, considering costs over the life of the goods or service and policies in the planning process, such as potential increases in energy prices, encouraging sustainable solutions and innovation in tenders, measuring and improving sustainability through the life of the procurement. Now, this is another, not a procurement connected policy, but something that the CPRs require you to do, and it's often overlooked or not properly understood. So I wanted to talk about it today. That is, CPR 4.7 says very clearly, in addition to value for money considerations are clauses 4.4 to 4.6 or rules 4.4 to 4.6 for procurements above 4 million, except procurements that are covered by Appendix A, and procurement's understanding offers, officials are required to consider the economic benefit of the procurement to the Australian economy. So it is a requirement. It's in part 1 of the CPRs, so a breach of it is can come with some serious consequences, particularly in light of the Government Procurement Judicial Review Act. So for every procurement over $4 million, you need to consider benefits to the Australian economy somewhere, and that's got to go into your evaluation reports, that it's been considered, so the auditors can make sure that it has. And this requires officials to gather appropriate information on economic benefits as part of the decision-making process and document how economic benefit has been considered. So what is a domestic benefit? There's some good helpful stuff on this actually around the place, which I've just captured here. What does it mean to have a domestic benefit? Making better use of Australian resources that would otherwise be underutilised, such as employing people, making use of spare industrial capacity, or freeing up government funds for other spending. Otherwise increasing productivity, e.g., for example, adoption of new know-how or innovation enabling more people to acquire in-demand skills, or ensuring that resources are allocated to sectors in which Australia has a comparative advantage. Next one is where you provide a broader benefit that supports the development and sustainability of industry capabilities, such as enhancing key industry sectors through sovereign industrial capability, Department of Defence's sovereign industrial capability priorities, for example. Next one, productivity enhancing technology development and adoptions can also deliver economic benefits, such as research and development, transfer of technology to Australian business, Indigenous workforce participation, engaging a business that provides services of persons with a disability, traineeships, apprenticeships in areas of skill shortage, boosting a supplier's international competitiveness. So that's some useful things there on broader benefits. And lastly, how can you provide a domestic economic benefit? From the supplier's perspective, they can put in competitive pricing, for example. They can build, lease, or procure infrastructure that benefits Australian communities. They can provide skills and training that benefit Australian communities employing workers in Australia. They can employ apprentices or trainees in Australia. They can pay taxes in Australia. Or the environmental benefit of the proposed solution to Australia can reduce environmental impact through energy efficient inputs or use recycled materials or content. So we sometimes, you come up against a bit of resistance as a procurement professional or legal officer in anywhere really, but in my experience with the Commonwealth, you get a lot of people saying, well, how can we show this, or how is an official supposed to consider this, or what does this really mean, or how can a tenderer, kind of give us anything on benefits to Australian economy in their response. And you can only do what you can do, and tenderers can only do what they can do, but there will always be a benefit. So that there will be, and it only needs to be considered as well. It doesn't have to be determinative, but it needs to at least be considered. And then what you do with it, you do with it. But this is important. So like I say, there it's quite simple. Putting in a competitive price that benefits Australian economy. Just having that's one. If you're looking for anything else. Procuring things in Australia, employing people in Australia, paying taxes in Australia because you're buying things in Australia, there's stuff like that. So, there's always going to be something that you can say to something like this, is basically my point. And this information and these sorts of guidance material is publicly available. So, a tenderer can find it just as easily as anybody else. Other benefits, there's a whole long list of them. So it goes on. Contributing to positive social outcomes in Australian communities, using Indigenous business, using SMEs in delivering goods and services directly or as a subcontractor, developing and adopting innovative products or practices that develop Australian communities, sharing knowledge, creating export opportunities for Australian goods and services, using goods and services from a business that provides services to persons with a disability, and so that's on there again, or developing Australian industry capabilities and industrial capacity. Okay, so that's brought us now to the end of that. If you've got any issues, or if you need any help with the Commonwealth Contracting Suite, where to use it, where not to use it, and the policies, if there's anything that wasn't clear, please feel free to reach out to me and I'll be happy to help you further. Otherwise, thank you for tuning into this part 9. I hope you've enjoyed all of them, if you've come to all of them, and look out for invitations to some more procurement presentations next year.